Massachusetts has one of the most complex and tenant-protective lease termination frameworks in the entire United States. If you own rental property in the Bay State, you're operating in a legal environment where the eviction process is slow, the procedural requirements are exacting, and the consequences of mistakes are severe. The governing law is found in Massachusetts General Laws, Chapter 186, which covers landlord-tenant relations, along with Chapter 239, which governs the summary process for eviction. Let's start with no-cause termination. For tenancies at will, which is Massachusetts' term for month-to-month arrangements, either party can terminate by providing written notice. The required notice period is at least one full rental period or 30 days, whichever is longer. In practice, this means most at-will tenancies require at least 30 days' notice. The notice must be in writing and should clearly state the date the tenancy will end. Massachusetts has specific requirements for how the notice to quit must be served. Acceptable methods include personal delivery or leaving a copy at the tenant's last and usual place of abode. The notice to quit is a formal legal document in Massachusetts, and courts scrutinize it carefully. Using incorrect language, wrong dates, or improper service methods can invalidate the notice and force the landlord to start over. For fixed-term leases, the lease expires at the end of the agreed term. Massachusetts does not require additional notice to terminate at the natural expiration of a fixed-term lease, unless the lease itself requires it. However, if the tenant remains after the lease expires and the landlord accepts rent, the tenancy converts to a tenancy at will, subject to the standard notice requirements. Landlords who want to avoid this conversion should stop accepting rent and serve a notice to quit promptly. Now let's cover termination for cause, and this is where Massachusetts becomes especially complex. For non-payment of rent, the landlord must serve a 14-day notice to quit. Under Chapter 186, Section 11, the notice must demand the rent owed and inform the tenant that if payment is not made within 14 days, the landlord will commence eviction proceedings. If the tenant pays the full amount within the 14-day window, the notice is void and the tenancy continues. Here's what makes Massachusetts' non-payment process particularly challenging for landlords. The state has an extremely robust right of redemption. Under Chapter 186, Section 11, the tenant can pay the full amount of rent owed, plus interest and court costs, at any time before the answer date in the eviction case. If the tenant makes this payment, the case is dismissed and the tenancy continues. This right of redemption cannot be waived in the lease, but it gets more complex. Even after the answer date, Massachusetts courts have broad discretion to allow the tenant additional time to pay. Judges frequently grant continuances and stays to give tenants the opportunity to come up with the money or to apply for rental assistance. The practical result is that non-payment evictions in Massachusetts can take significantly longer than in most other states. From initial notice to physical removal, the process can take 3 to 6 months and sometimes longer. Massachusetts also limits when a landlord can begin the eviction process in relation to late fees and grace periods. If the lease includes a grace period for rent payment, the landlord cannot serve the notice to quit until the grace period has expired. And the notice must demand only the rent that is actually overdue, including late fees or other charges that are disputed, can create problems in court. For lease violations other than non-payment, the landlord must serve a notice to quit, specifying the violation. Massachusetts does not have a single statutory cure period for lease violations. The required notice and the opportunity to cure depend on the nature of the violation and the terms of the lease. For curable violations, providing a reasonable opportunity to correct the problem before pursuing eviction is expected. For violations that cannot be cured, like substantial property damage that has already occurred, the landlord can proceed directly to eviction after serving the notice to quit. For serious violations, including criminal activity, drug offenses, and conduct that seriously interferes with other tenants' quiet enjoyment, Massachusetts provides specific grounds for eviction. Under Chapter 139, Section 19, if a tenant is involved in drug activity or other illegal conduct on the premises, the landlord can pursue eviction. The notice requirements still apply, but courts may schedule these cases on a faster track than standard evictions. One of the most important aspects of Massachusetts' termination framework is the defense of habitability in eviction proceedings. Under Chapter 239, Section 8A, if a landlord files for eviction, whether for non-payment or other reasons, and the tenant can demonstrate that the property has housing code violations that the landlord knew about, the court must consider this as a defense. The court can reduce the rent owed, dismiss the eviction, or impose conditions on the judgment. This means that in Massachusetts, a landlord who files for eviction while the property has unresolved code violations is walking into a legal trap. The tenant's attorney will raise the habitability defense, and the landlord may end up worse off than before they filed. This Section 8A defense makes it absolutely critical for Massachusetts landlords to maintain their properties in full code compliance before initiating any eviction. Having a current certificate of inspection, or, at minimum, documentation that all known code violations have been addressed, is essential before serving a notice to quit. The eviction process in Massachusetts, called summary process, goes through the housing court or district court. The landlord files a summary process summons and complaint after the notice to quit period has expired. The court then schedules an entry date, and the tenant has the opportunity to file an answer. Discovery and motions practice can follow, and the case eventually goes to trial if not resolved. Massachusetts's summary process timeline is longer than in most states. From the filing of the complaint to the initial hearing, the process typically takes 2 to 4 weeks. But contested cases, which are common in Massachusetts, can take several months to reach trial. The state's housing courts handle a heavy caseload, and continuances are frequently granted. Landlords should plan for a total timeline of 3 to 6 months from notice to physical removal in a contested case, and potentially longer in complicated situations. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has 10 days to appeal. If no appeal is filed, the landlord can request an execution, Massachusetts' term for the writ of eviction, and a constable or sheriff carries out the physical removal. The execution remains valid for 3 months and must be carried out within that period. Massachusetts also has a specific provision regarding stays of execution. Even after a judgment for possession has been entered, the court can grant the tenant a stay of execution, essentially delaying the physical eviction, for a reasonable period. Stays are commonly granted to allow the tenant time to find alternative housing, especially during winter months or when the tenant has children. This additional discretion makes the Massachusetts eviction timeline inherently unpredictable. On the tenant side, Massachusetts provides extensive grounds for early termination. If the landlord fails to maintain the property, as we covered in our Massachusetts habitability video, the tenant has powerful remedies including rent withholding, repair and deduct, and lease termination. The state sanitary code and the implied warranty of habitability give tenants significant leverage. Active duty military members are protected by both the Service Members Civil Relief Act and Massachusetts' own military protections, which may provide additional rights beyond the federal law. Massachusetts provides early termination rights for victims of domestic violence, rape, sexual assault, and stalking under Chapter 186, Section 24. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protective order, a police report, or a written statement from a qualified professional. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, cannot retain the security deposit solely because of the early termination, and cannot report the early termination as negative rental history. Massachusetts also provides early termination rights for tenants who are 60 years of age or older, or who are disabled and need to relocate to public or subsidized housing. The tenant must provide at least 30 days' notice and documentation supporting the need for relocation. Massachusetts strictly prohibits self-help evictions. Under Chapter 186, Section 14, any landlord who directly or indirectly takes possession of a dwelling unit from a tenant through force, threats, or the shutting off of utilities, services, or other acts is liable for damages. The penalties are among the harshest in the country. The tenant can recover actual damages or 3 months' rent, whichever is greater, plus costs of suit and attorney's fees. Courts in Massachusetts enforce this prohibition aggressively, and violations can result in both civil liability and criminal penalties. Massachusetts' anti-retaliation protections under Chapter 186, Section 18 are exceptionally strong. A landlord cannot increase rent, decrease services, or attempt eviction within 6 months of a tenant exercising their legal rights, including making a habitability complaint, contacting the Board of Health, withholding rent, or joining a tenants organization. Any adverse action within the 6-month window creates a presumption of retaliation, and the burden shifts to the landlord to prove a legitimate, non-retaliatory reason. One critical practical consideration for Massachusetts landlords: the state's Consumer Protection Statute, Chapter 93A, can be invoked in landlord-tenant disputes. A landlord who engages in unfair or deceptive practices, including improper evictions, illegal lockouts, security deposit violations, or habitability failures, can face treble damages plus attorney's fees under Chapter 93A. This exposure to triple damages makes Massachusetts one of the riskiest states for landlords who don't follow the rules. Massachusetts requires landlords to return the security deposit within 30 days of the tenant vacating the property, along with an itemized list of any deductions and a statement of the condition of the property. The security deposit must be held in a separate interest-bearing escrow account at a Massachusetts bank, and the tenant is entitled to receive the interest annually. If the landlord fails to hold the deposit in escrow, fails to provide the required receipt at the start of the tenancy, fails to provide an itemized statement of condition, or fails to return the deposit within 30 days, the landlord may forfeit the entire deposit and could be liable for treble damages plus attorney's fees under both the security deposit statute and Chapter 93A. For the complete guide to Massachusetts lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel so you stay protected in every state.